Pitch it up.
May I please, Your Lordship?
Yes, please.
Your Lordship, the item number 1, Your Lordship.
Hmm.
The the Advocate General appears in this matter, Your Lordship. Due to bereavement in his family, Your Lordship.
The learned Advocate General, Mr. Saikia, would be addressing the court in these two rate appeals. He is in bereavement, thus a request is made on his behalf to adjourn the matters, re-notify on
Your Lordship, after 2 weeks, Your Lordship.
After 1 week, my lord. In any case, what happened?
not 1 week, so it will not be possible. Not
My
be
lord, what
possible.
happened, my lord?
We know what happened. We know very well what has happened. Followed list after 1 week.
Wait me.
1 week is 1 week.
After. Oblige, Your Lordship.
My lord, item number 5.
Yes.
My lord, here, my lord, we were asked to take steps by Dusty Service, and we have taken steps and also filed affidavit, my lord.
Let the matter be called out. Wait for your turn.
Yes.
Number 6.
6.
My Lord, the service report may kindly be added. Service report has not been received.
In which one?
6.
6. Mangalena service report, call the service report. All right. Get the service report from the office.
Thank you.
As per the report, not received. Wait for your turn, sir. Orders matters, let them be called out. Wait for your turn. Don't make mentions in orders cases.
May I please, your lordship?
Hmm.
This contempt petition has been due to non-compliance of the order dated 23/3/2023.
Hmm.
And operative date is
Which contempt petition, madam? You are mentioning which matter?
item number 7.
So you need to speak out. What do you want in that? What do you want? Let the matter be called out. Why you are making a mention? You want to withdraw it?
Notice issued.
So let the matter be called out. Wait for your turn.
Okay.
Right now mentions are going. Yes. Hmm.
May it pleases your lordship, with the consent of the other side, I beg to mention with regard to item number 19, lordship.
Yes.
Lordship, kindly adjourn the matter for the day, lordship. My senior is out of station, lordship.
You are for the appellant.
Appellant, lordship.
I'm for the respondent.
Who's your senior?
Mr. S.P. Chaudhary, lordship.
It is stated that arguing counsel, Mr. S.P. Chaudhary, is not available today. A request is made to adjourn the matter. The other side has no objection. List after 2 weeks.
Interim order may be continued.
Interim order shall continue till next day.
Much obliged.
Much of it.
May I please, Your Lordship, my Lord, I'd like to mention, my Lord, for listing of a matter on Friday, on Wednesday, my Lord.
What is the matter?
My Lord, work order has been issued in favor of my firm, my Lord.
Hmm.
But my firm has not been arraigned as a party in the repetition, my Lord, and subsequently a single judge has set aside the work order, my Lord.
Okay,
So, my
Wednesday.
Lord, Wednesday.
Wednesday.
Obliged, my Lord.
May it please, your lordship?
My lord, I have come from Silchar. My
Hmm.
lord, my petition appeal may kindly be heard by tomorrow, my lord.
What is your writ appeal about?
Appeal, my lord, second division petition is maintainable and it was dismissed. But second division petition is maintainable according to the Real Tobacco Limited.
What is the title?
State
Let's
of
see.
Maharashtra.
We'll get your file. Wait for a while. Get his file. What is the file?
May it please, your lordship, I beg to mention item number 85 of part 2 hearing list, lordship. I mentioned it on Friday, lordship. Last Friday.
85.
Lordship, there is an urgency, lordship.
What is the matter? So already the matters are coming up.
Lordship, there is an urgency, lordship, matter relates to non-payment of salary, lordship, since 2006. And
What
I'm
is
the
the what?
respondent.
Let's see the sec part 2 list. Show it.
There is a stay order also, lordship.
Just let's check. You don't have a printout of part 2. Okay. Let's check. Place the file before us. We'll see. We'll call the file and then direct listing of the matter.
My please, your lordship. Lordship, I paid for listing of a writ appeal on Wednesday, my lord. What has happened, that, my lord, in this matter, my posting as the residential school coordinator has been set aside by the landed single judge, my lord.
What is the date of the impugn order?
18/09/2023, my lord.
All right, Wednesday.
Highly obliged, my lord.
May I please, your lordship? I paid for listing rate petition, your lordship, new matter, and tomorrow, your lordship, there is some urgency.
What is the urgency?
Urgency is that the district magistrate Dibrugarh passed an order on 9/9/2023. I have received the same on 59, thereby directed the authorized officer, the circle officer, to take over the possession.
Why the writ would like to the division bench?
Division is land, your lordship, loan matter, your lordship. Surface Act matter is there. yeah.
Surface yet. All right, Wednesday.
Witness. Obligation.
May it please your lordship. I beg to mention an item, a writ appeal for listing on Wednesday, your lordship.
Is it a fresh matter,
It
madam?
is a fresh matter. Your
It's a writ petition.
It's a writ appeal, your lordship.
Okay, what is the date of the SB order?
21st of August 2023, your
So
lordship.
then what is the urgency?
The urgency in this matter, your lordship, the appellant was initially selected for a specific post. by
All
the
right,
respondent
get it
on
listed on Thursday.
Monday, like, your lordship.
Okay.
May I please, your lordship? My lord, I beg to mention item number 10, who may allow to withdraw this petition.
Then
with
counsel for
liberty
the,
to the alternative remedy. With liberty to avail the alternative remedy.
then counsel for the appellant. Petitioner craves liberty to withdraw the instant writ petition, seeking leave that the petitioner may be permitted to avail the suitable / appropriate remedy for ventilating his grievances. Accordingly, the writ petition is disposed of as withdrawn with the liberty prayed for.
Obliged.
Daily list for orders item 3.
Me, please, your lordship. Lordship, the building committee, there was some deliberation. Lordship will kindly see office note dated 22/9/2023. Presently, my lord,
The request of PWD has been accepted.
yes, my lord,
Yes.
and some stress assessment by IIT
Hmm.
has been sought for regarding what will be whether there will be any damage with regard to the septic tank,
Hmm.
and there is a drain. That there is a communication. Your lordship will find that is dated 22/9/2023.
Hmm.
Last page of the office note, wherein, my lord, the executive engineer, my lord, he showed some apprehension with regard to, my lord, damage of retaining wall and the connected drain. So
Hmm.
that's why express
So
assessment.
let the PWD and the IIT make the assessment
Yes, my lord, that
Uh,
is sometime.
in view of the minutes of the meeting dated 22/9/2023 of the Honorable Committee for Buildings and Infrastructure, Guwahati High Court, the PWD and the PWD in consultation with the IIT is directed to take appropriate measures.
Yes.
Will re-notify on
Before Puja vacation, a date is something.
17th October.
Yes.
I'm sorry,
Highly.
I'm sorry, my lord. Lord.
Item number 4 along with item number 20.
Counsel for the petitioner is not filed. What is the IA 20? That is an leave to appeal. That must be the leave to appeal. Let the item number 20 be called out. The counsel is not here.
Item number 5.
May it please your lordship. My lord, this matter relates to settlement of fishery, my lord. Here we have challenged the order.
What happened after the impugn order? That is, there is no stay.
No,
There must have been a fresh settlement.
No, my lord,
Why?
not yet.
Who is there for the department? Can't be for 2 years, there is no settlement.
Deputy Commissioner, it is not the fishery department, it is Deputy Commissioner.
Deputy Commissioner.
Yes, my lord. And
Mr.
the
Sharma,
Deputy
can you take
Commissioner
instructions?
affidavit, my lord.
Instructions, my lord, in this regard.
Because the order, there was no notice. It was just put up on the notice board and the settlement was made. Totally illegal. It has been interfered.
Affidavit has been filed by the Deputy Commissioner, my lord.
What does he say?
It is in our favor, my lord. Your lordship may kindly peruse.
They of course supported you even
Yes,
in the
ma'am.
writ petition.
No,
That
my
was
lord.
absolutely justified, unjustified. Yeah.
They have justified their stand, my lord. At
How
para-
come? How?
Para 3, 5, 6, 7 and 10 of their affidavit, page 48, my lord.
This is, my lord, supporting the impugned order, my lord, because the impugned order has been, my lord, passed in favor of the, my lord.
Para,
Para 3, 4, 5, 7 and 10.
you are referring to the
May I read,
affidavit
my
in
lord?
writ petition.
Affidavit, yes, my lord.
So
filed by the
we'll
Deputy
see, we'll
Commissioner.
see. Right now, record of writ petition is not there. It's IA only.
My lord, we have filed affidavit in writ appeal also, my lord.
You have filed.
My lord.
It's not being tagged. All right. Affidavit in proof of the service upon the respondent number 4 has been filed. Which the supporting documents indicate that one, Zahira Begum, being the secretary of the Baba Noor Ali SHG code 30305. This is not on the correct respondent. It's been served on village Rampur, whereas the respondent is village Neelam Bazar. Just
My
check.
lord, Dusty, sir, we have served notice by Dusty service.
On a wrong address, madam. It's not the correct address.
But they have received, my lord.
Who? We don't know who is Zahira Begum.
My lord, I have
No,
annexed
no,
the receipt.
Madam,
my
on
lord, along
whom the
with
service has
affidavit.
been effected, please check the writ appeal,
My lord,
the notice, read the notice.
my lord, signature is also there, my lord. She
Whose?
is Zahira Begum, my lord.
Read the address. What is the address of the respondent?
But it was served by hand, my lord.
What, to whom we don't know. There may be another SHG by the name of Baba Ali in a different village. That's what it seems.
She is one of the members of the.
We can't say, madam. We can't say. No.
Neelam Bazar, my lord, district and post office, Karimganj.
Yes, yes. All right. Perusal of the receipt annexed with the writ appeal indicates that service was effected on one Srimati Zahira Begum, secretary to Baba Noor Ali SHG village Rampur.
Village, this is her address.
District
Residential
Karimganj.
address, my lord.
However, the respondent as described in the writ appeal is Baba Noor Ali SHG code 30305 through its authorized secretary Srimati Tahira Begum, village Neelam Bazar, TS and district Karimganj. Thus apparently, the notice has not been properly served. Steps be again taken, whereafter fresh notice be issued to the respondent number 4. Rule is made returnable in 6 weeks. In the meantime, Learned Counsel Mr. Sharma shall apprise the court regarding the steps for fresh settlement, if any, taken qua the fishery in question.
Item number 6.
Because no stay order is operating in this writ appeal. Yes, let's see. What is the report on service? No report regarding service of notice has been received. Then
So I have a service report, I have a service.
we'll await.
Hmm.
Await return of notice for 2 weeks.
Or you can serve another registered edition.
Let's await for a while. Let's see.
Item number 7.
May I please your lordship? This contempt petition has been due to non-compliance of the order dated.
What was the direction in the order?
Page 18, my lord. Annexure B.
Dipali Burman. All right. Issue notice to the respondent. Steps of service be taken in 3 days, whereafter process be issued. Rule is made returnable in 6 weeks. Heard issue notice. Karna. All right.
Item number 8.
There is a delay of 18 days.
18 days. What do you say? Who's there for the respondents? 18 days delay. No objection. Delay unknown. Let the rate appeal be numbered and listed.
Similar matter pending, rate appeal pending, lordship. Similar rate appeal pending, lordship.
So you want us to connect it with that?
Arising out of same judgment.
Rate appeal be numbered and be listed along with so and so.
Item number 9.
May I please? My lord, this is with regard to non-implementation of a select list. Okay. Now, my lord, the facts are like this. 120.
What kind of selection?
My lord, no,
Walk-in
selection, my lord,
interview.
800 posts were selected in that manner, my lord. What had happened during that COVID period time, my lord, 800 permanent
That
posts.
exigency no longer exists.
No, that's what I'm
Yes.
trying to explain before, my lord. My lord,
Yes.
my lord did not even go into that.
128
128 posts of ICU technicians were, my lord, created permanently. And these were, my lord, in the district level hospitals, which at that point of time were treated as COVID hospitals. Thereafter, my lord, the advertisement was made for 108 posts. 99 were, my lord, selected. Out of that 99, only 40 joined. COVID period, my lord. What had happened? The government allowed that 40 and re-advertised the 67 posts. 67 posts, my lord, 22 were selected. And we are amongst that 22. We were called for document verification.
Okay.
21 appeared for the document verification. And thereafter, my lord, the select list was published. And we were told that we will be given our appointment orders at a venue to be notified. And the matter remained as such. Then, my lord, as the select list validity was to be over, we approached this honorable court. They filed affidavits in September 2021 saying that we have, my lord, now that COVID situation as is, we will take all these posts together and in future, we will cancel the select list. My lord, will mind the stand, my lord, cancel the select list and go for fresh recruitment. Now, what they did, my lord, out of the 67 posts which were advertised, my lord, people did not join. 22 joined, 21, my lord, document verification. The balance, my lord,
22, which are the appellants here?
appellants here,
Okay.
14 are before your lordship. The balance, my lord, 47 posts were again advertised. And those people were appointed, my lord.
Yes, what do you say?
Lordship, they cannot claim appointment, Lordship. They were selected, but they can only ask for a consideration, Lordship.
Gentlemen, why you appointed thereafter 47 posts again?
Lordship, that is instruction I do not.
Where is that pleading, Mr.
My lord would find it at page 173. The advertisement.
Why you excluded these in this press advertisement? Why you excluded these two 21, 22 odd posts?
Lordship,
Come to 173, please.
This is the advertisement, my lord. This is sometime in, my lord, December 7th, 2021, my lord.
Your stand was that we'll club them together in the entire quota of posts
Lordship.
and readvertise them. But
Lordship,
you don't proceed accordingly.
Lordship, may I have a look at page 167, Lordship?
Yes, please.
Lordship, may I read, Lordship?
Yes, sure.
In the first advertisement whereby 108 posts of ICU technicians were advertised, 99 candidates were selected, but only 40 of them have joined their respective assignments. As a result, 68 posts remain vacant unfilled. These 68 posts were advertised by the second advertisement. That is by the advertisement number so-and-so issued by the Director of Health Services Assam. This time only 22 candidates were selected against 68 posts so advertised, and 21 of them have appeared qualified in the document verification. As such, out of the 68 posts, 47 posts remain vacant. These posts have now been advertised.
So you admit that the remaining 22 are not vacant. They are seeking appointment against that selection only. They have been selected. You don't say that they have not been filled in because you go for fresh recruitment for remaining 47.
But Lordship, they can also appear, Lordship. Weightage will be given, Lordship.
Why they were supposed to? They were already selected. Did you cancel their selections?
No.
Keep your secretary present then. This is utter nonsense.
My lord, we'll have page 163. They stand in the affidavit. My friend was reading from my reply, my lord.
Yes,
My lord, we'll have 163.
Yes.
That's the preliminary. The health department is looking after the infrastructure already created and is likely to create even more number of posts depending on the need requirement. As ICU management is critical to the life of the patient, therefore department government is contemplating to have a comprehensive recruitment of such posts with due attention to the skill of the applicants in the relevant service. In view of the above, the government therefore proposes to issue fresh advertisement at a later date after cancelling the earlier select list.
Yes.
Further, the select list has lost its validity. This
Already
was in
issue notice to
September.
the respondents. Then counsel Mr. So-and-so appears on their behalf. The respondent number 3, Director of Health Services shall be required to join the hearing of this writ petition by VC mode on the next date. Re-notify on 4th October.
Lordship. Much obliged.
Or let it be the secretary.
Lordship, in that case, Lordship, let notice be issued, Lordship. They are praying for 22 posts to be kept, Lordship, vacant, Lordship. I'll take the instruction and file an affidavit to this effect, Lordship.
You already have filed your affidavit in the writ petition.
Lordship,
Why a fresh affidavit is needed? Or have they advertised the post again?
No, not till now. If they advertise, my lord, I'll come back to you, Lordship.
Yes. 4th October. You are not appearing for the respondents.
Yes, Lordship, I'm appearing.
If you say so, then we'll call them personally.
No, Lordship, I'm appearing.
Don't change your stand.
Much obliged.
Respondent number 2, Secretary so-and-so shall be required to join the hearing of this writ appeal by VC mode on the next date, that is 4th October. Respondent number 2, Principal Secretary, Health and Family Welfare Department.
Much obliged.
Item number 11.
Yes. You want a direction for change in alignment of road.
Yes,
Is it that is permissible? Read one judgment of Supreme Court which says so. That road alignment can be changed by the red court. Be prepared and come back. Okay.
Lordship, can the matter be taken up then on Wednesday?
All right. Friday. Listed as paid list on 29th.
Obliged.
Item number 12.
This writ appeal is preferred against the single bench order, my lord. The lordship will find a single judge order at page 20, page 20.
In the earlier writ also,
Yes.
there was a categoric finding that your possession is not legal. It's a VGR land.
Now,
What
earlier
to do?
petition, my lord, at page 81, your lordship will find 1999 judgment, my lord. Page
Come to
81,
para 14 of the impugned order.
page 14.
14, para 14,
Yes.
page 8. Yes.
But this is the observation of the honorable single judge with utmost
In
respect.
the earlier writ petition.
Earlier
Let's see the judgment. All right.
I have annexed the earlier petition, page 81, my lord.
81. Let's see the judgment.
Yes. That was filed by petitioner son.
Srimanta Hazarika.
Yes, yes.
Hmm.
He died, then his father is living. Your lordship will kindly see page 84 below, my lord, last paragraph.
Hmm.
I dispose of this writ petition with a direction that a certified copy of the order and copies of the writ petition, including all annexures, will be filed by the petitioner before the Deputy Commissioner Jurat and Secretary Revenue Department, Govt. Assam, and within a period.
What happened on your applications?
My lord, there is a direction for settlement. Directly, my lord, court has said for settlement. Now these have, my lord, attained finality, my lord. Against this
Yes.
order, they have not attained.
Who's appearing?
Now they are saying different thing, my lord, for the first time.
Yes, Ms. Burpuzari. The learned single judge seems to have misread that order. of 1999.
No, my lord.
Ah.
He has twisted the figure. My lord, lordship will kindly see at page 84.
Yes,
My lord, in my,
there's a direction for settlement.
absolutely.
You
But
say that it can't be done on the VGR, give them alternative settlement.
my lord, that is true. But there is a condition precedent to that. They will have to move an application. My lord, lordship kindly see it is a qualified.
They have
matter.
never moved an application.
Absolutely no.
We have moved, my lord. We have
No,
filed
there
page
is no
75.
record. Yes.
But that point was raised before the single judge, my lord. We have filed our application. Your lordship will finally see page 75. The court asks us to file an additional affidavit.
Hmm.
My lord, your 76, your lordship will see an affidavit to bring on record the relevant documents relating to communication of the order dated so and so.
Hmm.
And this was the affidavit filed, and we have annexed the judgment, page 81.
Judgment is all right. Where is your
Yes,
application?
and page 86, your lordship will see the postal receipt sent to the revenue.
That you sent the judgment.
In 14/10/99, my lord, page 87.
Hmm.
From my counsel, my lord, it was sent to them along with the postal receipt. So far, my lord, other petitioners, my lord, they have not sent.
Then
So
this
we-
is simply a communication of the order.
Yes,
You had to file an application in terms of the order. You never did.
no, we did it. This is the page 86,
Let's see.
page 87.
What is the
my lord.
prayer?
Page 87, your lordship.
Read. It is simply narration. It's a synopsis of events.
Yes,
It's not a prayer for settlement.
yes.
Then
Then after page 87, my lord, when we have communicated, my lord, then the respondent, my lord, circle officer, page 89, they filed the affidavit for the first time stating that the land is a VGR land, my lord. It's paragraph 4, my lord, page 90.
hmm.
For the first time, they said, my lord, on the basis of this, they never disputed earlier, my lord, stated that it is a VGR land. And petitioners are,
What was the affidavit in that writ petition? 1999? Or there was no affidavit?
no affidavit, my lord.
That is a problem. We pass orders without waiting for the response of the respondents. That is the problem.
My lord, whatever it may be, my lord, it's a VGR or what, my lord, these things have become final, my lord.
No,
Now
there is
they have-
no finality. You never filed the application. So you have forfeited your rights by
No.
laches.
We have stated, my lord, your lordship will kindly see,
Where
appreciate.
is the copy of your application? And if you had filed the application,
Yes,
why you were sleeping for so many years?
my lord, the position is same from them to till now. There is no disturbance from them, my lord. We filed a writ petition because, my lord, we want that settlement.
So now there is already a record, material available on record that is a VGR land. Can't be allotted.
My lord, that is, we are saying, my lord, learned single judge, my lord, have stated that it's a VGR land. My lord, that is.
That is their affidavit. Have you counted it?
For the first time they stated, my lord.
Mr. Counsel, this is a position as emanating from the record.
Yes.
You can't dispute it.
No, the VGR land, my lord, there is certain settlement rules is there, my lord.
Yes.
Settlement.
So for that purpose, the settlement has to be done in a particular way
Yes,
to compensate the land first and then to allot.
the learned single judge, my lord, observe on the basis of the affidavit, there is a VGR land.
Yes.
Nowhere we have stated in our petition is a VGR land.
You will not state so, obviously. Why
And-
you will state so?
But the thing is, my lord, the VGR land, my lord, there has to be a settlement rules provide, notice has to be issued first, then DC has to, my lord.
Why would they do
a
it? You
inquiry.
never applied. Had you applied, they would make that inquiry.
Yes, my lord, I pay 77, my lord.
Ah,
Page 77, kindly see paragraph 2, my lord. That the page 77, my lord. That the petitioner above named stated by judgment and order that this honorable dispose of the writ petition with a direction to the.
Mr. Barua.
Yes,
The direction was that you file an application without there being an application. Why are they supposed to indulge in that kind of exercise?
my lord, their stand is that it is a VGR now.
Oh,
they are
that is
saying-
now they are saying, obviously, you come up, you wake up after 20 years. 22,
We are,
23 years rather.
we are doing tea cultivation there. as a source.
All right, carry on happily. You don't need any order of the court then.
No, only thing is, my lord, the observation of learned single judge, their land belong to a VGR land. It is without any material.
Did you controvert their affidavit?
Your lordship, I have brought the cause list, my lord. The matter was disposed of at a motion stage, my lord.
That doesn't make any difference. We do it every day. When was the affidavit filed?
By the
Respondent.
page 89, my lord.
Yes.
They filed it, my lord, on 14th of December 21, my lord.
And when was the writ petition disposed of?
Disposed of on 27th of 4, 2022,
22.
my lord. The hearing was completed, my lord.
Yes. So 5 months time you had to controvert that affidavit.
My lord, I have stated in my ground, my lord, that that case was taken up for disposal, my lord, on that day, my lord.
So what
On the-
prevents
on
the
the-
court from doing so? 5 months party doesn't apply the CPC provisions. How long do you get to file a rejoinder?
Now, my lord, thing is that, my lord, VGR land, my lord, if it is had to be on based on materials, because the deputy commissioner has to submit a report, my lord.
Why they were supposed to? They are saying so in affidavit. We don't understand.
My lord,
You don't dispute that fact.
Kindly, lordship will see, they are stating that there is already a mini stadium in the VGR land.
Yes,
Land is already.
it can very well be used for government purposes.
Yes.
There is no dispute.
Yes.
Yes,
But-
so,
But the stand taken by them that it is a VGR land in respect of the petitioner, my lord,
yes.
is a, well, a dual stand they have taken, my lord.
Why a dual stand? Government facilities can very well be constructed by compensating the VGR land. That is not the controversy.
Well, the same DAG number 156.
Yes.
They say there is already a mini stadium, my lord, granted.
What is the problem in that? What is the illegality in that? Are you in a red petition saying that that one should also be demolished? No.
No, we
So
are
then,
not,
if
nobody.
your land is you are encroaching on a VGR land, you have to be ousted. Can't
No,
be settled.
No, my lord, my thing is that my submission is not a VGR land, my lord. Because a deputy commissioner.
Mr.
as
Barua,
per-
we are sorry to say you are not understanding the things. You never controverted that submission. Keep on saying that the red petition was disposed of so and so, so and so. What you are doing for 5 months.
My lord, with utmost respect, my lord, that yes, this dispose of, my lord, with the, on the prayer of the earlier other petition, it was taken up, my lord. In our case, my lord, common.
In your case, when was the affidavit which you are reading filed? Again, let's reconsider that.
14 December 2021, they filed the affidavit.
They filed the affidavit. You got a copy?
I got a copy, my lord.
Then date of disposal of the red petition? April 22.
April 22 was the hearing was completed, my lord. And we got the certified copy after.
Forget it. That is why you are not ousted on the ground of limitation.
Now, our point is, my lord, it's not a VGL land, that is. Because they have stated, my lord, for oblique purpose. My lord, what
Okay.
purpose?
Thank you. Anything else to say?
My lord, your lordship will kindly appreciate the single judge order, my lord, once again, my lord. Your lordship will see page 29, paragraph 21, my lord. Page 29, paragraph 21, my lord. In the event of filing such representation by the petitioners as directed above, the deputy commissioner shall submit his report with regard to the land involved in the case within a period of 2 months before the secretary to the Governor of Assam in the Revenue and Disaster Management Department. Thereafter, the secretary to the Governor of Assam in the Revenue and Disaster Management Department shall pass necessary order on the basis of said report of the deputy commissioner.
Yes.
With regard
You
to
already have been given liberty. Take steps accordingly.
Yes, it is in the same line, my lord, with that of the 99 order. 2 times they were given the liberty. They did not avail. There is a condition precedent, my lord. I will have to comply it, my
I
lord.
think
I cannot
order
have
is
taken
taken
it.
finality, my lord.
Okay, very well. Thank you.
The single judge order is not against us, my lord, but. only thing
Rejected.
is
Thank you. Dismiss.
obliged.
Item number 13.
In this case, lordship had granted me 3 weeks time to file additional affidavit.
Hmm.
That's being filed today, my lord. The person couldn't come earlier, my lord, because of
Okay.
difficulties.
Mr. Datta submit that he has filed the affidavit of the appellant in
Affidavit, my lord,
terms of the,
as well as an application for my lord infringement, my lord.
he has filed the affidavit, additional affidavit and an application seeking improvement today. The same be brought on record. Matter will be listed thereafter.
Definitely obliged. Definitely obliged.
Item number 14.
Departmental proceedings.
My lord, I will be allowed to call DYSGI, my lord. His name has been shown in the cause list, man.
Call him.
Yes, ma'am.
Does he need an invitation card or what? Hmm?
He's not-
All right, we'll pass it on.
Item number 15.
Yes.
This last order wanted them to have the instruction with regard to the question is whether it will be governed by 2010 policy or 2017 policy.
Hmm.
Our case was, you know, that the NIT was issued in 2014. LOA was issued in.
What do you say, Mr. Gupta?
My lord, the license would be governed by the 2017 catering policy, my lord. 2017.
Come to order dated 19/6. That is the order you are referring, Mr. Goswami?
Yes.
Yes, Ms. Gupta, you have a copy?
No, I don't have the.
You joined the train in the midst of its route. That is the problem. You're not there on the earlier stations.
They took time to get instructions, you know, because the government of India has given directions that maintain the status quo of 1919.
May pay for.
31,390.
The orders are up online. You need to take out all the orders. You don't have the orders on your record.
No, I am appealing, my lord, on behalf of SGM today. No,
Where is he?
the-
He has been arguing this matter regularly. Is he in town or not?
that is not in town. Not in town, my lord.
Earlier matter, we should have dismissed them. Madam was saying that she is calling him. What happened? Where is your deputy SGI?
When is it coming? Next week?
I'm sorry to say, madam, that case is my case, madam. Item number 14. My name has not been, so that's why I missed the case, madam. Item
Okay.
14.
Next week.
Ms. Gupta, what do you want? What do you want today?
Would-
All I did is stated that deputy SGI, Mr. Chaudhary, is not available today. Re-notify after 1 week.
Okay.
What do you want in 14, madam?
That means the case means my name
Oh,
has
wait.
not been shown, my lord. Next, any date, my lord.
MSA Gayan submits standing council, Central Government of India, submit that she has been instructed to appear on behalf of the appellants in this case. And since her name was not displayed in the cause list, the case could not be marked. Registry to rectify the error, display the name of MS Gayan in the cause list and re-notify the matter after 1 week.
Master Blessed.
Item number 16.
Actually, this is directed against the order of the single judge also, single judge. Which starts from page 90, your lordship. And the relevant portion is that starts from 111, your lordship, paragraph 30. May I read it, your lordship? In that view of the matter, and taking into consideration that the appointment letter dated so and so was issued, was not by an authority competent under the rules of 1977
Yes.
to do so, and there being no materials which is so that the petitioner was appointed as per the mandate of the law above referred. This court is not in a position to issue a writ in the nature of mandamus to compel the authorities to release the salary of the for the period from so and so to the date of alleged superannuation of the.
Yes.
So, this
So her appointment was never as per the rules. What kind of direction?
that is not the factor also. The rules, I have an extract of the rules, your lordship, that's page 113, your lordship, have a look. On the right hand side. About 10 lines from below your lordship.
Page
113.
113.
And lordship may also have a look at the book also.
Yes, all right. What do you want to point out from that?
This is about 10 lines from below your lordship. It is inspector of schools, district elementary education officer, block elementary education officer, and deputy inspector of schools, and in any other manner as the government may deem fit, as and when they are received from the different subdivisions. So the appointment letters may be issued by the DEO also. In my case, your lordship, the district elementary education officer issued the order. That is at case 24, your lordship. After selection, your lordship, was appointed, and that was your lordship ratified.
Come to para 16 of the impure order.
Lordship,
Read, please.
that the action will be responded of the appeal, your lordship.
It is relevant to take note. Para 16
Para one.
of the impure order.
Page 101, para 16 of the judgment.
It is relevant to take note of that there was no proposal so submitted to the cabinet in respect of those teachers coming within the fold of list 3, that is, who neither received any salary nor qualified with the training, that is JBT stroke D elementary education in respect of the petitioner. It was further mentioned at paragraph number 10 of the additional affidavit that the name of the petitioner was found in the screening committee's report under Borpeta district and not Baksa district. And as per the screening committee's list under Borpeta district, the petitioner had neither received any salary nor had completed the junior basic training, and therefore she did not fulfill the criteria laid down in the cabinet memorandum, for which the petitioner's case could not be considered for accommodation as teacher tutor with prospective effect pursuant to the cabinet approval dated so and so. The screening committee's report, insofar as the petitioner is concerned, was enclosed as an annexure A to the additional affidavit.
Yes.
So your lordship, the
Mr. Sharma, tell us, you claim that the petitioner was appointed in 1999. She never received any salary.
no,
Then she comes to the Red Court after how many years? 18, 19 years. Is it acceptable? Can it be believed?
because lordship, I was under the impression that
Such a charitable person, then all right.
because I was supported by my husband, your lordship, during that period.
Gentlemen, now, whether this can at all be accepted? Where is your attendance? Who's to verify that now? Sorry, on delay itself, you are not entitled to it.
Because the school has all the records, your lordship.
Maybe, why,
that I attended
why
the
you were
school
sleeping
for 30
from
years.
1999?
Yes, I rendered my services.
Why you were sleeping for all those 40
without
years?
Paid. Your
Why you
lordship.
were sleeping? Why didn't you approach the court immediately? Even a month's delay, people come to the court.
No, lordship,
Sorry.
There are other cases also in which the petitioners were given the relief, your lordship. In the
Which
same-
other case? Let us see one judgment, please. All right. Mr. Mazumdar, this third category, have there been any other writ appeals? The learned judges classified the matters in third list.
Not to my knowledge.
Yes, which judgment?
That I have not annexed, your lordship.
All right, you need not annex, but you can cite if you have a copy.
That is in respect of your lordship.
All right, bring the judgment next date, list after 4 weeks as prayed.
Okay.
So if the standing council BTC needs to be mentioned in the.
Name of standing council BTC shall also be reflected in the cause list henceforth. Okay.
Item number
Bring the
17.
judgments on the next date. We'll consider.
Item number 17.
Not allowed, your lordship.
What has happened
My lord, the authorities have now, my lord, undertaken an exercise, my lord, for allocating an alternative plot of land. But they are searching for it, my lord. On the last occasion, I have placed it, my lord. I am again.
Searching means it's a escaped criminal that you can't find.
My lord, the Guwahati, my lord, lordship is well aware, my lord, it is already separated, my lord. Still then, my lord, authorities are, my lord, wholeheartedly, my lord, doing that exercise. Now, out of 2 kathas, 10 lesser of land, my lord, they have found, my lord, that 1 katha, 10 lesser of land is, my lord, uninhabitable. So that has been damaged. Nonetheless, my lord, with regard to that, 1 plot of land has already been, my lord, settled. Settlement was made. Only 1 rupee, my lord, premium as a nominal premium, token premium. That, my lord, the writ petitioner has visited now. He is complaining that that land is not suitable for him. Now again, my lord, these authorities are again swung into action.
So otherwise, the authority, if his fears were not genuine, the authorities would not have done this to search for another piece of land. They are just showing him lands which are absolutely of no worth, not habitable. What is the point then?
My lord,
Now we are giving you last opportunity of 10 days.
lordship will
Give
kindly
him proper piece of land,
lordship will
or else we'll initiate suo motu contempt then.
My lord, because my lord, the report direction was, my lord, either to grant him, my lord, alternative plot of land or to pay him compensation.
Yes.
Lordship, that aspect of the matter is also open. So lordship will kindly accommodate me for 4 weeks. If within 4 weeks, my lord, we are unable to find any alternative plot of land, lordship will definitely take a call, my lord.
All right, Land Council, Mr. Borpuzari submits that since the petition, the respondent has expressed dissatisfaction regarding the settlement made in his favor by the order dated 9/5/23, the authorities are now looking out for another suitable of land which can be a suitable plot of land for settlement in favor of the respondent herein. He prays for and is granted one more opportunity to do the needful, re-notify on 7th November.
I am so obliged, my lord.
Item number 18.
Please, your lordship. Lordship may pass over the matter for the time being, lordship. Counsel for the petitioner would like.
What is the matter, Mr. Mazumdar?
Lordship, the issue raised that in violation of the Assam excise rule and ignoring the public protest, the authority has taken initiative to issue license in the residential area.
Pass over.
Lordship,
What is the stand of the respondents?
they have filed their affidavit and they have stated that some complainants have withdrawn their complaint and some complainants have not withdrawn, but they are not.
What about your allegation regarding the allotment having been made contrary to the rules? What is their stand on that?
Regarding that, my inquiry has not been conducted. That is admitted fact.
What is your stand?
The appeal for the private respondent.
Private respondent. All right, pass on.
The affidavit of the special respondent have made it clear, my lord, the inquiry, 2 inquiries have been.
All right, we'll see. Pass on.
It will come in the course of hearing. Lordship may fix another date. Pass on.
Another date,
No, my lord, I'm suffering, my lord. I paid the license fee, I've spent around 3 lakhs.
re-notify on Thursday. Come back on Thursday. Standing council exercise is not available. List on Thursday.
Supplementary list, item number 20, along with item number 4.
28th. 28th. Item number. Yes, you moved an application for leave to appeal.
Yes,
Who's there? Education Deputy Commissioner. All right, issue notice of the IA number so and so to the respondents. Copies of the application be supplied to the standing council concerned who appear for the respective respondents. Steps for service upon the remaining respondents will be taken in 3 days. Whereafter process be shown.
Item number 21.
Regarding disposal of the representation, lordship directed the government advocate to obtain the instruction.
My lord, for my instruction, there was a state level committee meeting being held. And as per the decision of the state level committee on the 22nd of August, there was a decision taken. I'll just read out the relevant part. The committee decided to invite the bid in the form of packages. For this, the project shall be grouped into 16 packages, considering the logistic and practicability of the methodology requirement associated with the adoption of the new technology. So the government has invited on there was a meeting held on 22nd of September, where the appellants were also invited.
Heard. All right.
And they have informed the appellants that 16 packages were clubbed.
What is your
My
grievance?
lord, I think my learned friend haven't got the proper instruction. My lord, NIT was during the pre-bid meeting, we raised this issue, my lord. Most importantly, my lord, as per clause 6.4, entire exercise is to be done by a state level committee. It was not but done, my lord. It was done by another, no, my
that's
lord, it
what
was
he
done by
did.
another committee. These are
What she's
specific case
reading-
in our affidavit petition, my lord.
But she's providing official documents for that purpose.
No,
My
no,
lord,
no, I think, my lord, if your lordship would kindly.
this was a state level committee.
Let's see the document. Ms. Chaudhary, what about the meeting which was held on 22nd September? Do you have any idea?
No, my lord.
She says that there has been a meeting
No,
on
my lord,
22nd
no, my lord,
September.
we participated in the tender, my lord, sorry. Secondly, we participate in the pre-bid meeting where we raised all these issues, my lord. My lord, as such, it's very difficult to undertake work in my lord state of Nagaland because of the difficult terrain. Now, if a package is to be located in 2-3 districts, it will become absolutely impossible. And earlier it was never done, my lord. And as per the PMJSY guideline, there is a committee. That committee will take a call. Our case is, my lord, the committee has not taken that call.
Committee, there are minutes of the committee.
Yes,
Have a look at this.
my lord.
Give a copy. Madam,
My lord.
pass on a copy to Ms. Chaudhary.
My lord, can it be done this way, my lord? Let the matter be called after tomorrow. Let us have the instruction from our.
Then Government Council, Nagaland has drawn the attention of the court to the minutes of meeting dated 22nd August 23 held by the state level standing committee. Copy of these minutes have been provided to Mr. Chaudhary, who prays for short opportunity, complete his instructions. Re-notify
On Thursday, my lord.
Thursday. What about this meeting on 19th? What has happened?
19th, the meeting was held inviting the appellants in the hall of the chief engineer.
Inviting who?
Even the appellants by the department.
But what is the conclusion?
It's simply
You find out, Ms. Chaudhary. Ms. Chaudhary,
My lord,
find out.
I'll find out.
List on. This court is
Thursday,
further
my lord.
informed
Thursday.
that a meeting was of all concerned, including the appellants, was held on 19th September as well. Re-notify on Thursday as well.
Deep.
Hmm. कर दीजिए इसको लिस्ट कर दीजिए लिस्ट हाँ ठीक नेक्स्ट वीक Thursday is 20. Oh, they are connected, so 4 will be along with this. That is I only. ठीक है ना connect कर दीजिएगा उसको. What is the date? 28th September. Okay, done. No hearing matter.
I think to mention item number 9 of today's supplementary discussion.
Yes.
May be taken up in some other day, madam, after a week, madam. My senior, may be taken up in some other day, madam. My senior PD9 is after.
This is a bench specially formed for this purpose. Let the matter be called out. Just.
daily list for orders item 1 and 2.
Who has filed this review?
Uh,
State,
We have filed. Lordship.
what is it about?
Well, there is a direction of the honorable court to start the process of promotion.
Hmm.
And my lord, to complete the, there is a second direction that to complete the process within 2 months.
Hmm.
Well, we have come up for review before the honorable court because in the meantime, the government has initiated a steps now to bifurcate the department as well as to man the that particular position by ACS or IS officer. Well, in the file, the processes are there. On last occasion, Lordship has directed me to place the original records. I have the record. Lord. And the opinion of the highest law officer of the state was sought by the department, and that he has advised that since the honorable court order is there, so ultimately we have to seek a review of the order without the clearance of the honorable court. The permission of the honorable court, we should not go for amendment.
Yes.
And that is why we have come up before your lordship
Hmm.
for this petition, so that the department can go ahead with that proposed amendment.
So, Mr. Nath,
Lordship.
whatever new process you will introduce, that will be applicable prospectively. This direction we have given for the existing situation. How can you make that process retrospective? Let us know.
Well, since if the person is allowed to join.
All
the
right,
direction-
now, all right, tell us on the principles of review. What is wrong in the order?
No, there is, Malad, in fact, a review lies on any
Error apparent on the face of the record.
or
So-
any other sufficient reason,
Yes.
Malad, in my respective submission.
What?
Malad.
Any other sufficient reason under anything under the sky for the askance, right?
Malad, under the facts and circumstances, Malad, Lordship, see,
Hmm.
kindly, Malad, since there is a direction of the honorable court to
Hmm.
complete the process.
Yes.
And Malad, the department, although they have called for the documents of the eligible persons for that promotion process, but now Malad, the two things are in their mind, that they want to bifurcate the department and as well as to mend the post of director by the ACS or IS officer, because that is their administrative post according to them. Malad, they have because of the order, honorable court order, Malad, they are finding it difficult to proceed with that. Malad. That is why, Malad, we have approached the honorable court. So my respectful submission to the Malad, any other sufficient reason would cover that, Malad, because the government, the intention of the government and the direction of the honorable court, Malad.
Read the order. What is the reason for the direction given?
Lordship,
Come to the order.
at page 14,
Yes,
it starts at page 14 in the review petition.
yes. Read the page number 4, bottom 2 paragraphs.
Lordship. Mr.
A. Sharma.
A. Sharma, learned counsel for the petitioner in WPC number 4135 of 2018, has taken us to the Assam Geology and Mining Recruitment and Condition of Service Order 1988 as amended in the year 2000, by which mechanical engineers have also been eligible for promotion to the post of director, subject to fulfillment of other conditions given in the order. The case of the petitioner was that he is the senior most officer in the directorate, having all the requisite necessary for promotion to the post of director. In fact, he is the only one who has all these qualifications and therefore he must be promoted. The state in its counter affidavit in WBC number 4135 of 2018 has opposed the contention of the petitioner, stating that the petitioner is not qualified and he is an engineer in the mechanical branch. Whereas for the post of director, the main requirement is expertise in mining or geology. All the same, in spite of repeated opportunity in this important matter, WPC number 2594 of 2017, where a challenge has been made to the amendment made in the 1988 order, none of the official respondents, including the additional chief secretary or the in-charge director of the Mines and Minerals Department, has filed its counter affidavit, and therefore on 4/1/22, we had closed the opportunity of the state to file its counter affidavit. The reluctance of the state officials in not filing counter affidavit in spite of repeated opportunities has no satisfactory explanation. Today, we have been informed that in WPC number 4135 of 2018, there are now more than one candidate in the department who are eligible for promotion to the post of director. We therefore dispose of both the writ petitions with a direction to the state government to initiate the process of selection for promotion to the post of director in the geology and mining, Assam, in accordance with law. The two petitions are disposed of accordingly.
Yes.
When did you initiate the process for bifurcation?
Well,
Any documents in support of your review petition?
well, I have the, yes, Lord, I have the records, Lord.
Forget about the record. What is the pleading? Why should we look at the record? It's your review. Satisfy us from your pleadings. Read. When did you initiate the process? Your review. You don't file any pleadings in writ petition which is pending since 2017.
But
You come out with a review petition without any pleadings whatsoever. Read para 6. When did you initiate that process?
para 6, Lord.
Hmm.
The review petitioner respectfully states that in the meantime, the department at the highest level wants to bifurcate the existing director of geology and mining by creating two separate independent directorates, namely namely Directorate of Geology and Directorate of Mining, wherein the technical scientific work shall proceed under Director of Geology with all personnel under Director of Geology and administrative responsibility, license permits, etc., including revenue collection shall be with the Director Mining, who shall be from administrative IAS, ACS background.
When was this decision taken? Or when did the process start? Read from your pleadings.
Final decision has not been taken.
When did
because
the
of the
process
honorable court
start?
order.
When was the process initiated? Tell us.
Well, from the record, I can refer. Malad.
Mr. Nath, we are reading your review petition.
Correct, Malad.
Satisfy us from that.
Malad, the part of the records, the office notings are not incorporated here, but the ultimate, the process.
Even
progress.
the dates, the months, the year, nothing.
Well, I have got the record, Malad. I can put it on record, Malad.
We don't know. As on date, your review is there and contempt is also there. So we'll proceed with the contempt for the time being. What do you say?
Malad, I have received the records. The electronic records copies are with me. Let me give it 2 days time. I'll bring up record the progress. of
That's
the-
very unfortunate on part of the state that they have made it a matter of prestige.
No, no.
We are not going to promote him, come what may.
No,
We'll
no.
change our policy. That is what is there. Why didn't you file a affidavit in the writ petition for 5 good years?
Malad, the records at that point of time, it was not filed, Malad. But the records were missing because of some sifting and all these things as have been indicated in that case.
6 years, Mr. Nath. 2017, the writ petition was filed. It came to be decided in 23.
2 petitions are there, Malad.
Yes.
That's correct, Malad.
Then all right. You just tell us now what is the error apparent on the face of the record. You may have decided to do it. Once he retires, do it then. Or introduce the rules, they make the amendment of the rules. What prevents you from doing so? So in future, nobody will be promoted from this stream. Simple as that. What is so complicated? What heavens are falling that right now you have to do it? For this intervening period, from the inception of the rules till now, how were the things carrying on? A director from the engineering branch was holding the post, a person from the engineering branch. Was there any problem in administration? Did you face any such difficulty that your entire functioning was put at a standstill because the person was from the engineering background?
No, that in absence of Malad, the information from the record, Malad, I can't submit.
Then Mr. Nath,
The
do it prospectively. What prevents you? We'll make it clear that prospectively, whenever the rules are framed, we'll leave you at liberty. When the rules are in place, you proceed accordingly. But for the present, there is no reason. Under the existing rules, in view of the interpretation made by the court, either you should have challenged that order, that no entitlement, equality in entitlement, the court has wrongly exercised jurisdiction. If you want to do it now, do it. But that has to be prospective. You can't put the things to standstill. We'll make it clear then. All right.
Malad, with records and all these things, Malad, I'm very clear. The mind of the I have also Malad, got the logic. Give me 1 day time, Malad. I'll just take up and come back, Malad.
Okay. Re-notify on Thursday, 2 p.m.
Can it be on Friday? Malad? Can it be on Friday? Malad?
Friday.
Lordship. Thursday, I also have some prefix hearing in some.
No later than. All right. On Friday at 10:15.
Lordship, in the meantime, I may be permitted to file an application for impleading the present.
You do that.
respondent.
You do that. We'll permit you.
Obliged, my lord.
Two, ठीक है, 2 p.m. करेगा.
Commentary खबर.
Mr. Nath, please for time. In the intervening period, Mr. Sharma is permitted, when counsel representing the petitioner in contempt case number so and so, is permitted to substitute the respondent
Number 3.
/ respondent number 3 by the present incumbent holding the post. All right.
Obliged.
Item number 3.
Made a loss. So it was kind of the loss, what are dated 7/8/23. The revised scale of pay matter, the regularization was rejected. But it was just our claim is a revised scale of pay matter, who is the other similarly the person of getting my. Page 7, order dated 7/8/23.
Yes.
Malad, here, Malad, I have some difficulty, Malad, because the concerned secretary, the Malad, she has undergone some surgery, Malad.
Okay.
Some time is required, Malad.
Mr.
I'll
Nath
get
submits
this,
that the secretary concerned has undergone a surgical procedure and thus he has been hampered state has been hampered in filing affidavit in terms of the liberty granted earlier. List up to 3 weeks so as to enable Mr. Nath to file the affidavit.
I'm obliged.
In this review petition.
Current salary also we are not getting, man. Current salary also we are not getting.
Current salary,
Look into the matter, man.
Mr. H.R. Chaudhary submits that the petitioner is not being paid the current salary. Mr. Nath shall ensure that the current salary is paid to the petitioners as per their entitlement.
Item number 4.
May I please, Lordship.
Yes.
My lord, we have sought some review of the order that Lordship may kindly see page 12. Operative portion may be seen page 16, my lord.
Your review is delayed, first of all.
My lord, a little.
A delay we have
I
known.
explained, my lord.
All right, yes.
Lordship may kindly see page 16 bottom. The only claim of the present appellant is for notional promotion to the post of CDPO from the year 2006 when her juniors were promoted. Under these circumstances, which we have already narrated above, we dispose of the present appeal with a direction to the state government to constitute a review departmental committee which shall review the case of the appellant for promotion from the year 2006 when her juniors were promoted to the next higher post.
Yes.
And Lordship, the Honorable Court also directed to constitute a review committee. In the light of the above, next para,
Yes.
in the light of the above facts, the review committee shall take a decision whether the petitioner present appellant was liable to be promoted in the year 2006 when her juniors were promoted. So, my lord, that review committee was constituted and ultimately review committee passed an order. Lordship may kindly see page 150.
Yes, please.
I am reading the second paragraph.
This word
150.
entitled. Yes.
Accordingly, a review departmental committee was constituted to decide whether Srimati Nikumani Saikya should be given the benefit of national promotion from the date when her immediate juniors were promoted to the post of CDPO in the year 2006. The committee, in its meeting held on so-and-so, decided to promote Srimati Nikumani Saikya, CDPO retired nationally to the cadre of CDPO with effect from the date when her immediate juniors, namely Srimati Vijaya Priya Devi, was promoted in the year 2006 by notification number so-and-so dated so-and-so.
Yes.
Further, since the claim for promotion was sought on a national basis, As per the direction of the Honorable Guwahati High Court, the committee has decided that no claim for area salary and other benefits shall be admissible. So, my lord, this is my grievance.
So this is a fresh cause of action. Why review?
And the review means
We have not said anything in that order that you will not be entitled to actual benefits or anything of.
My lord, in the order of the Honorable Court, it was ordered the notional promotion.
Let's see.
Now, notional,
So promotion will be notional since you have retired. Obviously, the promotion will be notional.
my lord, Supreme Court has also said notional promotion may also include the service benefits. If my juniors were promoted in the year 2006, my lord, let me satisfy your lordships.
Yes,
If my juniors were promoted in the year 2006,
yes.
and I have been promoted to the post of CDPO in the year 2014, that is, there is difference of 8 years. So 8 years promotional benefit I am not getting, not the retirement benefits. And the Honorable Court did not say. Honorable Court said national promotion. Actually, that was not our prayer at all.
Where is
Nowhere
where is the direction that notional promotion is?
And that page 16 bottom may be seen.
Yes, above the last.
So my only grievance is this, my lord. Unless if national promotion may be there, but Supreme Court has also national promotion may also include service benefits.
Promotional has to be exposed Notional benefits. Promotion for that day. Will be treated as promoted from that day.
That day.
But no actual benefits, notional benefits.
But salary and pensionary, everything.
A limited pair of hours.
Yes.
We don't need to make it.
We don't need to give it up. Yes.
When you
But the consequential benefits, Mr. Chaudhary, Mr. Counsel, she will get out because she will be treated, promoted from that day. But actual benefits she will not get, obviously.
Yes,
She will not get.
not get.
That is what the direction is. But the cascading effect will come. You know, actual monetary benefits will not be available, but that effect will be reflected in the pensionary benefits. That is what the concept of notional benefits is. That you will not get the actual salary for that period on the promotional post because you never worked on that post. It's a fact.
I was not working.
So
that
then
post,
why
that
should
is
you be
not-
given?
That is not, that is the duty of bureaucratic lectures. In spite
When
of
did
I
you
being
come? When did you
qualified.
come to the court with the filing the writ petition? Now let us know. Writ petition was filed in 20.
Yes,
When were you denied?
yes,
When were you denied? 2006.
yes.
You came to the court in 20.
No, my lord, I filed departmental petitions various times.
That is
Court
not
has
material
taken
at
up
all.
or
That is
taken
not
up.
material. No.
Now, my lord, my limited.
When you come to the court,
Let me provide the promotion. I have a widow, my lord.
it's
My
okay.
son is in.
Promotion has been given now.
Promotion has been given in
Yes.
paper. But in practice, I am getting nothing.
The
So-
consequential monetary benefits you will get in the pensionary aspect. That we can clarify. If you want, we can make that clarification.
I live in lordship.
Yes, Mr. Sharma.
My lord, if my lord, we read the direction part, my lord, page, my lord, 17.
Yes.
There was a direction for consider, my lord.
You have considered,
Committee and
you have considered your founder entitled.
my lord.
So now notional benefits will mean that you will treat that her salary was on the promotional post on 2000 as on 2006. You will not give her actual financial benefits, but that effect will be reflected in the pensionary benefits.
Even if assume, my lord, for a moment, my lord, in the said circumstances also, my lord, review is not maintainable. The petitioner may challenge.
It's just a clarification.
Challenge the, my lord.
It will not
order.
amount to a review.
My
It will be a clarification.
My-
We'll make it a clarification. As a matter of fact, Mr. Counsel, yes, he's right. That you are required to file a fresh writ petition. This has to be. They have promoted you notionally. This court observed. You have come out with a review when? You filed a review after 425 days. If you are aggrieved by that part of the order wherein the division bench wrote notional, then you should have filed the review then and there.
My lord.
You woke up
I
after this order of 27th September, right?
No, read petition may not be, my lord, I have so many citations review. What is the power and scope of review?
Yes.
The Honorable Supreme Court has. come
Let us
to-
see all right then.
Yes, my lord.
Satisfy
That I
us
have
on
given
that.
citations.
Yes.
I review for last of it.
But Mr. Sharma,
My lord,
once you have considered her promotion,
my lord.
is she not entitled to get the benefits?
My lord, I am not saying anything about the merit, my lord. Because. my
He's
lord,
only on the aspect
rightly
that
or
it's
wrongly,
ordered.
my lord, that order has been
It's
passed.
Post
It
the
is-
decision of the writ petition. If they are aggrieved by anything of that order, they need to file a fresh writ petition. That's what he says. Yes.
Yeah, my lord, if you lordship 2005,
Clarify.
or SCC have given citation.
All right, we'll make a clarification. She'll get the effect of the benefits in her pensionary payment. Okay. We'll make that clarification. You challenge our order in a superior court. Dispose of.
My lord.
It is presumed, no direction is required.
Obliged.
Drafted in form of a clarification.
Sorry?
Clarificatory kind of order. Yes.
Item number 5.
Yes. What is the review about?
Wait, please, your lordship. My brother was working in railway. So at the age of 53, he expired. He was a bachelor, my lord. The question arose, my lord, who will be entitled for the retirement benefit, not pension, my lord. Other benefit like provident fund, gratuity and all, my lord. So one lady, the writ petitioner, she lodged her claim for saying that this is considered her to be her as a sister. So that was, she filed a petition before the tribunal, my lord. Tribunal has said that she is not entitled because there is no relation, my lord. Tribunal has given a direction in our favor that we being the brother and sister will be entitled for these benefits, my lord. Now, against that, she has come before this honorable court, and the honorable court reiterated the same position regarding her entitlement. So for our entitlement is concerned, my lord, this court held that we are only entitled for DCRG and no other.
Death cum retirement. Yes.
My lord. Now here, lordship will find this honorable court first committed a mistake in holding that we are claiming for family pension.
No.
We are not
Okay.
claiming family pension, my lord.
Then what else?
Page 17, my lordship, kindly see.
Page?
17.
Yes. What else are you entitled to?
Lordship, kindly see, my lord, page 17.
Yes.
These benefits are not, these are one time provident fund, GIS, if salary, DCRG and miscellaneous fees, my lord.
Yes, yes.
So
These have to be given. Gentlemen, everything other than family pension.
Lordship.
Whatever falls upon the dependents, as per the rules, that has to be given. This restriction part is not proper.
and we obtained section certificate also, my lord. as
Yes.
per the order.
Yes.
For section 73, Lordship, it's recorded in page 86, Lordship.
86.
Page 86.
73 regarding
Yes, yes.
DCRG, my lord.
DCRG, Lordship.
Yes.
DCRG.
Page number 76.
DCRG has been given, my
86,
lord.
Lordship.
That
86,
that's what he is aggrieved.
Lordship.
That the red court should not have restricted it only to the death cum retirement gratuity. There are other contributions. Who else will take? What will happen to the provident fund of the employee?
Except family pension, others.
Everything else has to be given.
Say otherwise.
What is the rule?
Page.
86. Let's see.
Even Lordship,
The
the
order was
police
not on the
quoted in
challenge.
page 84, page 84, Lordship.
This is only regarding lapse. This doesn't house the other.
No nomination.
There was no nomination.
No,
They got a succession certificate.
No nomination, my lord.
Succession certificate, Lordship, in respect of the Lord, death come gratuity, Lordship.
No, everything, my lord. I have enclosed the certificate, my lord.
Otherwise, Lordship, the
Yeah.
paragraph 7 of the honorable court's order, Lordship.
Some regularity or retirement gratuity.
Mm.
Only two.
Oh, this provision deals. What are there are other rules regarding the other benefits?
Other benefits, provident fund rules should be clearly laid down there.
Provident fund rules.
But if it says that if there is no family, another definition, my lord, it will be shared as per the law.
Okay.
So the law inherent, it has come, my lord. It is clearly mentioned in the Provident Fund Act, my lord.
All right, enumerate the relevant provisions, please.
My lord, that Provident Fund Act, my lord.
Provident fund. Act.
Yes, my lord. Clause 70, my lord.
What has the tribunal done?
Tribunal has said that she is not entitled.
She is not entitled. So your entitlement, as a matter of fact, was not questioned by anyone.
Anybody, even railways wanted to give me, my lord, that document I have read over, my lord.
Only clarification.
Clarification ही चाहिए, ठीक है. So we will clarify that all retirement benefits, all terminal benefits as per their entitlement. We'll clarify that the applicants will be entitled to all terminal benefits as per law.
As per
As per law and as per their entitlement. We'll clarify. It will not be restricted to death come retirement gratuity only. All right, dispose. All right. This I'll dictate.
Item number 6.
May it please your lordship. Lordship had ordered it 28/4/2023. This honorable court has directed us to file an affidavit to bring on record the verification report, my lord. Lordship, we have received the verification report, my lord, but affidavit could not. Lordship, may kindly have a look at it.
File the affidavit.
Lordship.
File the affidavit on record.
My lord.
When council,
Friday.
Friday.
We'll have it on Friday.
Right, lordship. Lordship, may kindly give me 10 days time, lordship.
Oh, then we'll have to reconstitute the bench again.
Lordship, Friday, my lord.
Land council, MS also submits that the affidavit along with the verification report and the affidavit in terms of the earlier direction shall be filed within 3 days.
My lord.
List on Friday, Kardano at 2 p.m.
Deeply obliged, my lord.
Item number 7.
My lord, there was already an IA in a disposed of matter. I have been constrained to file another IA, my lord.
Why?
My lord, what had happened, just a background, my lord. I was a contractor with the FCI. My lord, there was a particular mention in the tender as well as the work order that distance is, say, my lord, X kilometer. I did the work. My bills were cleared. Everything was paid to me by taking the distance to be X.
Yes.
After around 4-5 years, my lord, basing on some report, they immediately, my lord, issued an order that 88 lakhs were overpaid to you because they reduced the distance. And thereafter, my lord, I was supposed to come before this honorable court. This honorable court interfered, honorable single judge interfered with that order, saying that I'm entitled to repayment of the amount. They came upon appeal, my lord. When the matter was being considered, they withdrew the appeal with the liberty that they will go before the grievance redressal cell, which is a cell on their own. Now, my lord, till date, whether I am entitled to required to pay that amount or not is not determined. Then after that order, I was satisfied because my lord had also directed that my payment should be released to me. I'm an ongoing contractor with them, my lord. They filed an IA. In course of the IA, hearing of the IA, my lord, there was a
IA for what purpose?
They wanted a collateral security.
Collateral security.
Then, my lord, it came down that I was appearing, my lord said, it was said that an undertaking is to be given to me.
Okay.
And I also agreed to that. But unfortunately, my lord, maybe because of an error of some, maybe I could not persuade. My lord, page
Solvent security.
Solvent
security.
Now, my lord,
what is there in the solvent security? What is the
because
problem?
my lord, solvent security, if I have gone to the bank, for 1 lakh, I have to pay 5,700 rupees. So 88.
Solvent security is your valuation of the property. It's not a bank guarantee.
My lord, they are not accepting that. They say either give us the full amount that you are pending with us.
All right, let us know the definition of solvent security.
Solvent security, what my lord said is correct. That
in Rajasthan, Mr. Nair, as we understand, in Rajasthan, the certificate is given by the Tehsildar, which may be the deputy commissioner, based on the valuation of your property.
My lord, I got this thing from my bank money.
Yes.
My bank, I got it that I am worth so and so rupees. I'm good for this much amount of money.
Yes.
But they are not accepting. What they want is, they want me to give a certificate that all my dues which are with them will be kept on a hold till this thing happens.
No.
I am ready to give an undertaking, my lord, because this amount, my lord, will only consider one aspect.
Please let us know what is a solvent surety from law. Definition of solvent surety from law.
I'll do that, my lord.
Friday.
Is sitting again on Friday, my lord.
Friday.
I'll come back on Friday.
Yes. You know, even in bail applications, we pass an order. Bail bond and sound and solvent sureties, then they are not required to get certificates from the bank.
But
that is this financial standing based on the property valuation.
My lord, I can get that from my bank because I'm a contractor. I can
Yes.
get it from my
So
bank.
that is
The
what
bank will
solvent
say
surety,
this will do.
that
But
is,
they are
that
not
is what
accepting.
solvent surety is.
What they are
We'll
demanding.
find the definition.
I-
We'll find the
I'll get that.
Yes.
I'll get that for you. Lordship. Much appreciated.
Item number 8.
Yes.
Mother, we have filed an application for condonation of delay 185 days
Mhm.
in preferring the review application.
Okay. What is the judgment under review?
222022. That starts at page.
What is wrong in that order?
Nothing is wrong in that order.
Then
Only there's an error apparent on the face of the document.
what is that?
My lord, we are a committee of workers of textile. Now, it was closed and there was a VRS scheme in force.
Hmm.
We had applied. It was not considered on the count that we are not on the rolls of the body.
Hmm.
Our stand is, of the 238 members, 105 had resigned, not the entire one. 133 had not resigned. And the second stand was the resignations of the other group was not accepted. These materials were a part of the record. Perhaps there was an error apparent to note that. However, the stand of the authorities were, they're not on record. So we are on the principle, there are two groups, my lord. One had not resigned. This was
What
not
do you say, Mr. Kalita, to condonation? This
Condonation,
come after Supreme Court judgment, basically.
that is correct, Lordship, but like, if your Lordship goes to that explanation part, there is no explanation.
So we
at
have
all,
said that
Lordship. There is no
238 members to consult and come to a point that, yes, we go ahead, took some time, paragraph 6. Nothing more. We
Ms.
were-
Kalita, we have to consider the review on merits because Honorable Supreme Court has observed.
Lordship.
After hearing the arguments advanced
Lordship.
by learned counsel, Mr. Banik.
Paragraph 6. 7. 7, sir. Page 7.
After going through the grounds set out in this IA seeking condonation of delay of 185 days in preferring the review petition. For the order dated 22/2022 in rate appeal number 61/22 and considering the fact that Honorable the Supreme Court by the order dated 11/11/22 passed in special leave to appeal number 18004/22 has given liberty to the petitioners to approach the court with a review petition, the delay is condoned. They let the connected review application be listed on Friday.
Friday.
Copy of the review petition, please provide.
Item number 9.
May I please get out?
Yes.
My lord, the review petitioner before your lordship is working as an assistant engineer in a minor irrigation department, state of Mizoram, my lord.
Yes.
My lord, he is aspiring for promotion to the next higher post, that is executive engineer, my lord. And the recruitment rules provide that the intending candidate has to have 5 years of qualifying service.
Okay.
And my lord, he also has to pass the department.
There was a request from the Mr. Nair in this case. So we'll have it on Friday then. Friday, 2 o'clock. Okay, done.